Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon have the opportunity to ask questions of our speaker. If you have a question, please type them into the comments section below, and we'll be sure to address them. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, we have Kari Jones with us out of Denver, Colorado to talk about the Damages College. Not to be confused with the damages portion of the closing argument college that Papa Don is still working on. Kari practices personal injury and bad faith law out of Denver in addition to being KTI faculty. And she also teaches direct exam with me and possibly other courses. As always, we'll put her contact information in the description below so that you can contact her directly with any questions about this college or anything else Edge. Kari, will you talk to us about the Damages College and what we can expect when we attend?
You can expect to have your life changed. Do you hear that every podcast from every instructor?
Actually, I don't know if we've heard that yet, but I know I've heard it from all of my students in all the courses I've taught.
Here I am, just blowing it out of the water.
Yeah.
So what's interesting, I was thinking about this in preparation for our conversation today. So I do teach the direct exam and then the damages. Those are the only two courses that I teach. But when I started teaching damages first, and then obviously we started to do the direct exam course. So teaching another course really showed me how these courses blend together in part of the system that we all use. And so actually, I must say that the ability to instruct more than one course, you have this mountain view looking down and seeing how all of this works together. So I want to say that. So I think if you haven't taken the damages course, obviously it is a key element to any trial because that's how we get our clients compensated, right? But what's so great about it, I think, is that you truly get to see how all of the other pieces that we learn in these courses fit together. I want to mention, I think you and I were talking before we went live. I had a trial a couple weeks ago, and I have to say that, do you remember when you started law school? I don't know if you had this experience, but you had to relearn how to think, right? Okay. Mm-hmm. So what this course did for me is it made me sort of get rid of all the law school bull crap, right? Because you think you've got that word compensatory in your mind, and then you think about your jury charges within your state. And so you just have this, no matter what, at least for me, you just automatically go there as habit in terms of thinking about your damages. It was mind-blowing in this trial that I had a couple weeks ago, how this course really just came to life in terms of the ways that you can look for what really your case is about. And I'll give you a bit of an example, if I may. Our client is 94, if you can believe it, a 94-year-old woodpecker because she doesn't quit. So she slipped and fell and broke her right hip and right elbow. And then a couple months later, as is common, she broke her left hip. And she survived, and she worked really hard. And what we learned about her, and this is another piece that I think is pervasive in all these courses, is in order to understand what the real damage for her was, we had to get to know our client. And that is key. And just a plug for the direct exam course too, that's a big part of that course as well. But we really had to get to know her, and holy crap, what we learned about her is she was one of the first female scientists at CU Medical Center here in Colorado, and she helped to do the research to develop the heart and lung machine.
Wow.
She was right. She was one of the only women when she looked around the room in terms of the work that she was doing. And so what came out of this, and what was very clear, was that the reason that she had survived after breaking both hips and not, being or succumbing to pneumonia, as most elderly do when they break a hip, is that she was a survivor, and she was proud. And so her whole world was her mobility. I mean, she was driving to Rockies games at 92 on her own. So and I would not have been able to get there, but for the damages course. So if I could just in a few words sort of tell anybody, any of our potential future students for the course, what you're going to get out of it is it retrains you in terms of thinking what your damage is, thinking outside of the box. It is not at all what you think of when you sit down to think about your case, how you're going to present your case at trial. You know, obviously it's not the medical bills, right? Don't use the words pain and suffering. Like, what is this? What is the real damage in this case? That's what this course gives you. Powerful.
Yeah, absolutely. All right, sorry everybody that I'm in the dark. My lighting is weird today. So anyways, I'll be speaking from the shadows for the rest of the hour. Oh gosh. Anyways, okay, so that's fascinating because I think we deal a lot in a world where, at least in personal injury, especially in admitted liability cases, we are buttonholed into talking about compensation. How have you overcome that? Because the trial that I was just talking to you about before we went live, we were stuck with compensation, and we like that's what the court wanted us to say. She wouldn't let us say. She'd never tried a civil case before, so she was very much led around by the nose by the defense lawyers.
Yeah.
But would this course assist somebody, which so many of our audience are people like this, who are handling admitted liability, car crash type cases, to look at damages differently?
Yeah, and so I want to get this out before I forget. So I think what is very unique about this particular course is whatever is going on in your case, maybe you have, and I think you've probably heard this before as an instructor, and I know I have, where it's the student that's like, look, I just don't have the Don Keenan cases, right? Like not every case, the bulk of my caseload doesn't require a life care plan. So here's what is contemplated in this course and why I think it's so great is that we've tried to account for every scenario that you could possibly imagine, whether it's negative things going on with your client, whether it's maybe, gosh, they got back to status quo after a couple months. Whatever the case may be, this course accounts for that and allows you to find the power of the rightful damages still in your case. So back to your question about admitted liability. Well, what I can say and what I think that we've learned, no matter what the course topic is with KTI, is that we all know that the concepts of foreseeability and deterrence always are key in every single case, even the admitted liability cases. And so what I think is so great about this case, and I mainly do car crash cases. I mean, that's my bread and butter. So these admitted liability cases are, 50% of the time I'm getting that. And that's what's so powerful about the black letter law, right? That we've all learned, but that is infused in this course as well. And that being foreseeability and deterrence. And how do you get there? How are you allowed to talk about that? Through your damages. And so great question. So rest assured, if you have the admitted liability case or you have a case where, thank God your client got well. And maybe I have a case right now that I'm trying in August. And my client, after about 8 months of treatment, she's doing just as well as she was the 5 minutes before the car crash. And so it's really, for that case, it's really going to be about what she endured in that 8 months of treatment and what value does that have. This course accounts for that and helping you find not only what is the actual damage, right? And how do you present that at trial? So great question. So honestly, it's in all the courses that I have taken, in terms of what stands out in my mind and accounting for all these different nuances that we have in our cases, this is the course for you that gets you there.
Where should I take this in my EDGE journey? As far as I'm taking a case through various courses, maybe I can't afford or don't have the time to take it through all the courses.
Yeah.
If I'm going to do this one, when should I do it? Why should I do it? That kind of thing.
Yeah, so you want to do it right away. because it goes back to case selection criteria, right? That's hammered into our heads. If we walk away with one thing from KTI, it's case selection criteria.
Yes.
And I've already had some cases this year where I was like, probably wouldn't have had that result if I would have just, right? So I'll admit that straight away. But right away, because just logically, I mean, why would we even proceed if there's really not going to be the damage piece in our case? I mean, we have to start honing that right away. And here's the other thing that I think this course is going to train you to do if you're not doing it already. What you can't do is you can't start to think about damages right before trial, because you're just not going to get there. It's not going to be authentic. And so, and I can, just in full disclosure, the trial that I had a couple of weeks ago, I jumped into the trial about a week before the trial.
Wow.
And what I discovered was this feeling of like scrambling, feeling like I was just scratching the surface, if that makes sense, because you can't get to the good stuff, the golden nuggets, unless and until you've just done the serious, hardcore legwork. And again, I'm going to pound the work that you do with the client, because you just can't get there with one or two meetings. I mean, you've got to take the time, spend the time with them. And again, I think this is pervasive in all of our courses, but going to the client's home, really getting to understand their life, because you are going to you're just going to completely miss the biggest, most valuable damage in the case if you don't do that. So I think right away, you got to do it right away. And the good news is, like most of these courses, you're going to get bits and pieces that will, when you take your next course, you're going to be like, holy cow, all right, I'm linking that now. I already know that. So it's going to flow. But again, I think it's got to be number one or number two. If you're just starting out, damages course is a starter.
All right, we have a question from the audience. So Kenneth Balan asks, how does damages course fit in with Papa Don's teaching that liability drives damages?
Oh, yeah.
Good question.
I know. It's so hard because I can't give you all the secret sauce, but I will tell you that concept, my friend, is front and center. So yeah, it is. And what you're going to get are your major truths for this course. I mean, that's going to be and here's what's nice about it too. And this is just in after teaching a course and having continued conversations with students, because that's something that we as instructors love to do, because we get to, if you get us your homework, we get to learn your case, and you get that much more out of any of the courses. And so what is common, as Jen and I can speak to, is that you continue to work with students about their cases, because it's such an information dump in those 2 or 3 days, depending on the course, and it just takes time to mesh and as you work and rework your cases. But I can 100% promise you that concept will be one that is discussed, and it is one that is going to be a main theme throughout this course. So please believe that will be a major, hopefully, takeaway if you take this course. And I think that rings true for all the courses, quite frankly. But absolutely, I can confirm for you in this course, you're gonna see it and you're gonna hear it. Great question.
Yeah. And that's that also ties back into your discussion of the case selection criteria, which I talked about that in my debrief of my case. I would not have taken this case had I adhered to the case selection criteria, right? But also liability driving damages, and that overarching principle that we talk about a lot in EDGE really begins with that case selection criteria. And
100%.
Is there a type of, and with your focus grouping and finding out if people care about your case, and
that's right,
the emotional scale of 1 to 10, where does this hit you, and those sorts of things are all within that liability driving those damages. Now, that's not to say people shouldn't be taking necessarily, if it is your practice to take car crash cases or whatnot. I mean, that is what you do, and that's perfectly fine. And Edge
Right.
also can assist with that. As Kari mentioned, this course also discusses how, the kind of the alternative to, if you don't have a disputed liability, how you still can drive damages with other black letter law elements, right?
100%. I think no matter what the course is, foreseeability is a starter, right? No matter what, even obviously in an admitted liability case as well. I mean, that's your starting point. So if you have a case like I'm going to try in August where the client thankfully got better after 8 months, right? So what is going to be key in my mind? Foreseeability, in terms of that being a damage in her case, given the facts that we have. And so I can't express to you, and in particular, things that you can say in closing arguments from the damages course that really bring things like full circle. And this is, as somebody who has sort of sought, trial education from many different venues, one of the things that I have always said, having done the Edge stuff since, when it was like 2012, is that it gives you because as students of law, we want to write it down, tell me exactly that is what you're going to get. So I can tell you that with this course, you're going to get a lot of that. And something that I think is incredibly unique, that was like, holy crap, I'm working on not swearing. I'm trying to get better at it. It's hard for me, to be honest.
I know. I never know if it's allowed. Are we censored on here? Are we not?
I know.
No.
Am I going to get my hand slapped because it's potty mouth?
You're ripped off the air.
I know. There's like a big red, something, X or something. But it will help you, no kidding, to look at your jury instructions. And how do I bring it home, particularly in closing arguments, with those jury instructions? What can I do? Because, 9 times out of 10, if we ask, in our last trial, we asked, can we change the way that the verdict form looks? Can we change the way, right, that the language looks? And 9 times out of 10, we get a no. So what's great about this course, particularly in closing, is you're going to get information on how to knock it out of the park. Because if you look at your state description, or the language that's used to describe non-economic damages, for example, boring, right? Just pain and suffering. Well, what the hell does that mean? How does that equate to the evidence that's been presented at trial? One of the brilliant things that you're going to get from that course is how to make that link, how to help the jury make that link. And it's astounding the way that it feels to be able to do that, because you almost see the light bulb come on, like, oh crap, that's how I take that piece of evidence, how I take the fact that the plaintiff can no longer do, for example, the fun run that she did with her husband for the last 20 years. How do I link that to what the jury instructions are telling me is a damage in this case? That is the stuff that you will literally get to take away, in your notebook, and go back to it every single trial, every single case, every single time a potential new client walks in the door. That is some A+ stuff, in my opinion, in terms of what's in the lineup for the course.
Yeah, absolutely. I find that to be one of the more difficult things to do in closing argument, because if you have, medical specials, usually we encourage people to waive those, but if you have them, you have them. There's a number, right? If you have lost wages, there's a number. If you have, there's these numbers, but then how do you quantify these non-economic or general damages? And those are the ones I feel like people, we have golden rule, right? You can't ask people to put themselves in the shoes of your client, but they do that. And if it's like, oh, I can't do the fun run, they're like, so freaking what? I've never done a fun run in my life. I don't even know what that means. I don't care. So it's like they all of a sudden, because they can't quantify it with a number from an expert, they put themselves there and they're like, none of this matters. So I'm going to give you a 0.
100%. So that is, because you're spot on. We can put on the evidence in our case, but when it comes time to closing argument, we're educating the jury on how to do this now when they go back in the room and deliberate. I think one of the most powerful parts about this course is we give you instructions on how to close the deal in real time. And that to me is just incredible. And even if your judge shuts you down and says, which they most likely will, you can't change the verdict form. I want standard. You can't change the language in the jury instructions. We backdoor that like we do everything else in this course. We find a way around it. So that's pretty incredible. So that piece, aside from just training your brain to think outside the box and what the real damage is in the case, those are two of the biggest in terms of takeaways that I think you're going to get from this course. That will just hopefully change the way that you look at a particular case when a potential client walks in the door.
In addition to learning about how to present things in closing, the damages and stuff, where else can I use the concepts of this course in my practice?
Great.
Throughout a case, I guess.
Absolutely. I mean, it should permeate, and we talk about that in the course, and give examples, which I learned through examples. Like I need to visualize it. But we will talk to you in this particular course about how to, no matter the witness, whether it's an expert witness, before and after witnesses. I know that concept is talked about in other courses, but trust me, all of these things will be hit in this particular course. But so that when you sit down to do your order of proof, you will know what your damages are, and you're going to be able to say, who can I weave in these things through? And there are some, and in some of the cases, some of Dawn's cases that are highlighted throughout this course are real-time examples of how you show a particular damage by way of example, maybe through before and after witnesses. I think, and here's the other thing too, and I understand this because every single course that I've ever taught, I get the practical questions, okay, but how do you get that into evidence? Or, right, are great questions. Everything that we teach in the course, we account for that. So we will tell you how to do it, how to get around potential objections. And that's what I think is so brilliant, because it's one thing to say, well, go do this, right? And then there's the real life. And students want to know, well, it's better, or in my state, for example, I can't ask for they may say I can't ask for a specific number. We can in Colorado, so I don't want to, but I get that a lot. And how does that work? This course accounts for that, because that's what I love about it, because we really try to think about where everybody's coming from, so that nobody walks away feeling like, well, I can't really apply any of that because of my state law or how things work. That's a great question.
And a lot of that goes back to starting early. Like you said, do this course early, start early, because a lot of getting things into evidence, as I found, is getting a foundation laid for them really early on, whether it be through an expert report or a deposition, or somehow establishing the validity and the authenticity of that evidence through the defense witnesses. You really have to bulletproof things early on so that you can do as much as you can. That you're always going to, well, I shouldn't say always, but there's always the chance you'll have a rogue judge who just refuses to follow the law. And that's, I hate to keep saying this, but we had that in our case. She would look at the black letter law and say, I don't think I want to follow this. I'm going to do something different. And that there's only so much you can account for in certain situations like that. But these courses, all of them, do talk to you about how you best can set yourself up for dealing with that judge at the end, right? Because trial is the end goal. 100%.
I mean, and that's a really great point. And I'll tell you, I feel like every state is like this, but we absolutely have, more times than not, have judges that just are sort of two categories. They know the law, but don't give a crap and refuse to. They're basically like, well, appeal me. I'll be retired, right? Or they're timid and they just, they kind of split the baby a little bit because they want to make everybody happy, and neither of which is good. So you're spot on. This course, like all the other courses, it's going to give you examples of how to backdoor things, right? If you can't say the word community or safety or whatever bull crap it might be, and we had that in our last trial too. We had, the classic motions eliminate on those issues. Then you just come up with other words, be a woodpecker, like Mr. Keenan tells us. But you account for all of that. And to your point about if you think about where this course is really going to, the legwork that you can do ahead of time, aside from starting with your case selection criteria, it's really deposition prep and especially your expert witnesses. Getting your witnesses to adopt and understand your theory of the damage in the case is incredibly powerful. And I think that's how you can backdoor a lot of these objections that you might get, is really through your expert testimony and just helping them to understand that this really is a big damage. Because I think a lot of times, at least for me, if you use some of the same great retained experts over and over again, they have a certain viewpoint on how they look at things. But if you work with them enough too, you can train them on, and they are absolutely willing to get on board. But that's a great sort of, when you're starting out your case, that's where this course can really be helpful in terms of building it. So by the time you're doing your order of proof, you've done the legwork. You're not trying to fit things in where you're gonna have a hard time fitting them. You've done the legwork in advance to get yourself there.
Yeah, absolutely. That's a really good point too, about making sure your experts understand the value of your case, because you go to them somewhat for advice a little bit, right? I know Don would absolutely shit a brick if he knew I said, like, don't go to your experts for advice, right? You know the case, the expert has to testify with your case. But oftentimes you can say, well, is there brain injury or is there not? Do I have enough here? That kind of stuff, right? You can go there. And then, but they need to understand your damages. And we've had nurse practitioners who attend an IME with a client and they come back and they say, well, your client doesn't have brain injury. I'm like, wait, I don't care what you have to say about that, okay? Because the way I'm presenting my case, the damages are something different than what you have maybe seen in the past about what constitutes brain injury, or, well, if you're not using a neuropsychologist, then you're not gonna, be able to prove there's brain injury or whatever it may be. There's all these traditional and ingrained things that a lot of lawyers who might look at your case and try to critique it, or like experts or whoever it may be. And the damages course does a good job of also addressing how you handle those things.
100%. And you brought up two points that I want to make, particularly with brain injury cases, and then also just dealing with the concept of pain, that I think the damages course is really going to be helpful, sort of, educating your experts. I have learned, thank God, what Edge has taught me about brain injury cases. And you're going to get a lot of the stuff that you all already know, but it's just going to be beefed up in the damages course. But it's so interesting what happens when you talk to your experts about whether they may consider some different factors in terms of proof that support your client's physical injury, right? So if you're talking about, before and after witnesses in terms of a brain injury, I can tell you that the damages course is absolutely going to help you in terms of language and the ways that you can speak to your experts about, hey, maybe, just maybe, would you be willing to consider some of the things that these before and after witnesses are saying about clients? Is that, and why would that be helpful to your medical opinion? When you talk about pain, and if you look at, I don't want to go down too deep in a rabbit hole here, but I'm pretty fascinated by this. If you look at some of the tests that they do, well, like an orthopedic for pain, and where, it's like the chicken or the egg, right? Is pain caused by the injury? Then is the depression that comes after, is that from the pain? And it's sort of this like vicious circle. But if you are able to talk to some of your orthopedic experts about some of the other pieces of evidence that you could put forth at trial that support the credibility of your client in terms of when they talk about pain and how it really impacts their life, would they be willing to consider before and after witnesses? Would they be willing to consider photographs of your client doing the fun run that they did for 20 years? Whatever the case may be, like, this is what I'm talking about when I say the damages course helps you to think outside the box. Like, what if you were able to take those things and get your experts on board? I mean, pretty incredible, because I think 9 times out of 10, you're going to find that they're going to say to themselves, well, sure. I mean, it certainly doesn't go against my medical opinion, why wouldn't it help to support? And it's just sort of mind-blowing how you can take those concepts and weave them into the experts that will be testifying.
Is damages where we get the expert checklist? I don't remember the interview.
It is not.
No. Okay. Okay.
Nope.
Well,
it is. I can confirm that. You definitely get checklists though.
yeah. Checklists are excellent,
Yeah,
everybody. Wonderful.
I mean, yeah.
But being able to talk to them about or interview your experts, which is why I brought up the expert checklist.
There we go.
I don't
Sure.
remember which one, but interviewing them before you decide to use them, which was one of my takeaways from our recent trial, is don't force the treaters, because a lot of times you're fighting them and they are probably going to be less likely to think outside the box because they're scared than an expert. So in the process of doing this and making sure you're able to put on your client's case in the strongest way possible, interviewing your expert ahead of time to see if they're open to these sorts of things.
You hit the nail on the head. So we have an orthopedic expert here that just started to be willing to do retained work. Had really only ever been a treater. And I think he was willing to do it because we did just as you said. And it's, I mean, it was sort of like a conversation where we made clear we are in no way the kind of lawyers that are trying to sway your opinions. We want it, the good, the bad, and the ugly. We just like to find out, doctor, how you work. What do you prefer? Would you be willing to advocate for our client, your patient? And just starting sort of gingerly, like, you're the expert, you know, we just want to, and over time, we were able to build a relationship with this particular doctor who's just turned out to be wonderful. I do think it's kind of like dating.
Yeah, it is.
Wouldn't that be interesting?
But it's like dating an egomaniac, because these
Oh my
doctors
God.
are like the slightest offense, like the slightest thing, you may not even know you're offending them, but the slightest thing that they feel off-putting, they just like, bam, gone.
Shut it down.
They're pissed, and it's
Lots of feelings.
especially
Lots of feelings.
Lawyers, you know. Yeah.
Yeah, and here's the other thing too that I've learned the hard way while we're on this topic, and that is that surgeons. Here's the other thing to test out ahead of time. Surgeons are the healing hands of God. Did you know that? That every surgeon, when they operate, you are healed, right?
Because they are, like, God, actually.
Oh my God. And so you're like, the question of like a permanent loss of mobility, well, no, that's not, I mean, I've operated on them, you know, go out into the world 100%. So that's something that, you know, you're going to have your experts that are always going to testify that way. We have that in a case coming up the end of June. And, you know, our client has had 5 shoulder surgeries, and including a total shoulder replacement. And it's like, you've got to be kidding me that there's no permanent loss of mobility. And so it's frustrating. So having those conversations early on and just kind of figuring out if they're willing to, you know, be honest about that. That's key. That's a really great point, because the expert piece is, well, in the approach. I think it's a work of art. That would be a great course. Is how to date your expert.
It would be really great, both experts and just any medical. Well, I would say any expert, because of course they feel like they are the expert in whatever it is. And if you have questions about it, or if you want them to approach things differently, it can. There's got to be a delicate way of addressing it. But then I think medical professionals in general, just because it's they, you know, a lot of times they'll say, well, you have my records. I'm like, okay, records aren't, you know, evidence. I can't just put that in front of a jury. You know, that would be great. Actually, that would be terrible. But, you know, it's a difficult situation.
Do you all have a group called Kaiser? Is that? Yeah. Okay, so that's the way. I don't know if it's the same with the docs there, but here they have a rule, like it's a wall. You can't. I've only been able to get one cell phone of a Kaiser surgeon, and he was very cool. That's because he liked my client and he liked his patient. But they're like, my records are what my testimony will be, which, as you just said, is incredibly unhelpful. But that, because if you can talk to them to bring it back to the damages course, there are so many nuggets of information that you can get from the course that you can 100% talk to your experts about. And I think it's going to be easy for them to get on board because it can be things like evidence independent of your client. So in other words, not coming from your client, their patient. It's coming from independent sources. And if you think about it, think about the way that we cross-examine the defense, medical experts. They only focus on the information that's helpful to their opinion, and they're unwilling to look at anything else that may support the plaintiff's claims in the case. And so anyway, it's just you will absolutely, hopefully walk away from the course understanding or at least having some ideas on how you can approach your experts from a damages perspective. It's a win-win.
What are some of the other tips you learn in the damages course about uncovering damages your client may not be totally cognizant of and how to show those to a jury? Yeah,
so that is such a great question. So that it's going to come from a couple different sources. And I know I've said this already, but I cannot stress to you enough how you are never going to get to the key damages in your case unless you put in the time with your client. And we all have those clients that you ask them what should be really tough, if you do the witness prep course, you have the clients that seemingly just have a wall. And you're just not connecting, but there's something below the surface. So what you are absolutely going to have to do is to spend the time with your client, do the work. If they're giving you sort of that tough edge, that stone wall, and you're just struggling to get through, that's where you talk to the before and after witnesses. You start to meet the people in their life, because if you can't pull it out of your client, then you should be able to pull it out from the people in their lives. Because otherwise you're just going to completely miss what may be the ultimate, most biggest loss, whatever the case may be. It just may completely be like this. If you think about, I think something that is really overlooked, particularly with our male clients, is how is what has happened to them impacting them in terms of intimacy?
Yeah.
Okay. So how is that there? And I swear to God, if when I think back to even just in the last 12 to 16 months with my male clients, the path always ends up in the same place. And the answer is that 100% it has impacted their lives in that regard, right? So the point being is that if you don't take the time to do the deep dive, you're just going to completely miss it. The good news with the course is, as I've said, I think it's pretty darn exhaustive in terms of all of the different areas that you could look. Now, it's not going to give you every single potential damage under the sun, because we couldn't possibly do that. But what it does give you is the tools to know how to go and find it. Because it gives you enough that it opens up your brain that you just start to see things that you never, ever would have seen before. Or better yet, that you never would have asked the damn jury for. You would have never thought to say, well, this is why you should give my client this verdict. You would never have even thought that you could do that. And having done that in my last trial, complete game changer. Never, ever would have gotten there. Never would have said things that I said to that jury, but for the course.
Will you share with us a little bit about that and how you used it and how you think it was effective?
Yeah, so I think the biggest way that we were able to use some of the pieces that fit from the damages course with this particular trial were absolutely with the before and after witnesses. And in terms of connecting these witnesses, and they ultimately ended up being family members, connecting them in a way and eliciting certain pieces of testimony that 100% told the story of this family. Because what we had on the stand, we have our 94-year-old client. But what was really going on is she had 5 children, and she was the hub, and her 5 children rotated around her. All of them lived within about a 5 to 10 mile radius around her home. And so it was really about discovering the story of the Hogan family in that case. And what came out from that was, and we only got this from just doing a deep dive with her family members and some of her friends, is what an incredible and resilient family this was. And so I think the way that that helped us is that it really put forth to the jury the fact that our client was a true fighter. And to get that testimony from her, I mean, she could sat there, you know, the thing where you say it without saying it. I mean, she sat there, she could sit there and talk about, well, I'm resilient. But how do you show the jury that without her saying it, right? And so what you're going to get from this course is we'll show you how to do that. I mean, you get that from other people, and you tell stories through them. And the stories tell the jury the thing that you're trying to tell them without saying it. Does that make sense?
Yep.
It's so like, and it's like all of the other KTI courses, this is also just a huge takeaway that I'm still processing every single day. And that's knowing when enough is enough. Because I think as lawyers, we like to hammer things because we just want to make sure their jury gets it. Well, what we do is we ruin it. So, and one of the many things that Mr. Keenan is so incredibly brilliant at is showing something to the jury, you know, no matter the witness, and knowing when to walk away. And enough is enough, right? Instead of hammering it or belaboring it. And so I think this course will hopefully help people if you're struggling with that, and knowing a little bit of this, a little bit of that, like what is enough, and in terms of presentation and how do you do it without directly saying, oh, I'm in pain, but how do you show the jury that without eliciting that testimony? This course is going to help you with that, because I'll be the first to admit that I struggle with that. It is a work in progress. It takes a higher level of brain power that I don't have, so I have to work at it really hard. But this course will help you with that. And even as an instructor, in doing prep work before the course, that's part of what I'm really doing, is if you do the homework, I'm looking at your case and I'm like, how can we, what are the potentials in terms of damages, and how can we take what we're learning in this course and how can they use that at trial? And it takes that brain power, at least for me, to understand and learn how we're going to get that testimony or that evidence out in a way that the jury gets it, it's artfully done, and it's not pounded in a way that's annoying. It's an art form. I don't think I'm ever going to master it, but I'll die trying. So
it is. It's really hard, and I mean, I tend to be a very literal person, and I tend to be very logical and facts oriented. Yeah. And I'm like, hello, jury, I put the facts in front of you. What is wrong with you? Why did you shit all over me? You know?
That is such a good way to put it, because I think that way too. Like, I think that, isn't that the whole reason why we do focus groups? Hello. Is because we have, like, you know, tunnel vision in terms of what we think is important, and then they smack us on the head and say, you're nowhere near, you know, what's important. But yeah, no, it is, you're spot on. So if you're like Jenna and I need help with that, this course is going to help you with that, because it 100% forces you to get out of your comfort zone. Well, like all the courses, but it really does in terms of thinking about what the damage is in your case. And it could be something so small and so minute. And then once you get it, you're like, holy shit, I had no idea that now it all makes sense, right? And when you find that thing, or maybe it's a couple things, but when you find it, interestingly, then you start to see it everywhere. And that's what happened in the case that I just helped to try is, oh God, then you start to see everything made sense. I mean, it even made sense in terms of some of the defenses that they were asserting. They said it was a slip and fall, and her son drove her to the hospital where she ultimately slipped and fell. So one of the hurdles that we were going to have to overcome was, why in the hell did he not drop her off at the front door? Because they parked and then walked. Well, you know, we had to learn what a woodpecker and honey badger our client was, and we had to, and then only in learning her history and how hard she fought at everything in her life did we learn, well, hell no, she didn't need to be dropped off. she never needed help a damn day in her life to walk anywhere, even though she was 92. Like her kids knew, don't ask because she'll get pissed. No, I don't need your help, right? I mean, we just would have completely like, and that was, a way to defend what they thought, what the defense thought was this huge defense in the case. So that's a great example of how, like, when you're searching for the damage, you can even help to find ways to rebut these stupid, silly defenses that are being put forth. But it forces you to do that brain work, like all the KTI courses, ultimately.
Yeah, absolutely. Start thinking more like a juror and less like a lawyer.
Yeah, I think that the more that we can do that, the better our lives are going to be.
I agree.
Yeah.
Does this course discuss kind of the seeing is believing type stuff as far as using illustratives, how to find illustratives, how to make them, and that sort of thing?
So yes, I will say obviously it's not the seeing is believing course, but I will tell you that it blends in 100%. You're going to get all of that, whether it's and I'm so hesitant. I don't want to give away too much, but there are going to be visuals, 100%. And in particular, when I discuss the jury charges, some things that you can do visually, and I'm talking like, let's say you wanted to do them on the fly. What's so great about it? You're going to get from the course, or if you have a low budget, maybe you just can't. You don't have the high impact budget, whatever the case may be, you're going to be able to do what you need to do from a visual standpoint, great question, because it's about showing the jury versus telling them. And there are so many amazing things that you're going to get from this, whether it's from before and after witnesses or the family themselves, whatever the case may be, you're going to get some really great ideas in terms of presentation.
How does the damages course differ from the trial course? They seem kind of both overarching in a way.
Yeah. So the trial course, and it's been, I think I took the trial course 2 or 3 years ago, but the trial course is great, obviously, because you have, the different steps, if I remember correctly. So here's what's great, I think, about the damages course. Everything that you learn in the damages course, you can infuse into each step of the trial course, if that makes sense, right? So I think they're going to blend nicely together, because no matter what, specific area you're talking about within the trial course, every bit of information that you're going to get in the damages course, you're going to be able to apply that. So actually, it's a nice, whether you take, damages first or trial course second, whatever the case may be, I don't think you can go wrong, because they're going to blend together. And something that I want to, just touch on that, in the direct exam course, and I know in other courses that I've taken, and I think that it's becoming more and more talked about in our courses, but is not forgotten in the damages course, is the concept of point of view. You want to talk about how we need to start thinking like jurors. And if that is a concept that any of you have struggled with as a student of KTI, I have to say that the damages course really helps to solidify in terms of considering point of view. And as I said, Jenna and I are instructors of the direct exam course, and that is something that we can affirmatively say. I don't think we're giving anything away by saying it's a powerful tool in the direct exam course as well. But in terms of getting yourself to do the work to think outside the box, a big part of what you're going to learn in the course is considering the POV. And so I just want to make sure that everybody knows that, because I have struggled with that. And I think that's just really just a part of being a lawyer, is we just, get that tunnel vision. But that's something that if you struggle with it, I think hopefully you'll have a good takeaway when it comes to considering, POV, at least from a juror standpoint.
Right. And I think probably of all of the POVs we encounter throughout trial prep and trial and everything else, is the most different from ours is the jury's. I mean, it really, for the most part, you sometimes, Mindy does the really wonderful POV video, and in some of the cases, the POV is with the plaintiff, but that is so rare.
So rare.
They're really the polar opposite. And you know, even in voir dire, if you talk to them about everybody needing to be on the same level and starting at the same, you know, beginning of the race together and all that sort of thing, they may pay lip service to that, but you're not really there. And so understanding where they're coming from and how you can get them to, you know, dig you out of the hole first and then put you in first place is super important. And they're all of our courses talk about that, but in particular, Damages does a good job.
Yeah, and you bring up a good point with Mindy's great video. I mean, it's just I think we have to assume that they're never going to view it our way, and if you kind of start there and build yourself, you know, from the ground up, and assume that you know, whatever, I think it's about like reworking whatever it is that you want the jury to understand. Reworking how you get that point across. And I am hopeful that the Damages course will help you to do that, because it's really about, you know, to tag on the scene as leading the course that you mentioned. It's really about, you know, showing them versus telling them, because we're so used to, as lawyers, you know, you do this, and which is just arrogant, right? But if you can, as part of, you know, when we know how Bubba perceives us, if we can step back and just let everybody else do the talking, I mean, the less talking we do, the better our case is, right? And so anyway, I just think that hopefully the Damages course, you'll walk away from it understanding a little bit better how to do that and not be such a, as I like to call myself, a bull in a china shop. Yeah. So, you know, like a delicate ballerina. Isn't that all it would like to be? Just dancing around.
A delicate, effective ballerina. You can just say a couple of things and then back out. And,
that's right.
Yeah.
Just in and out.
To be able to hold their hand and bring them along, but not tell them how to come to the conclusion. I have so little patience with that. And so that goes along with my very logical and fact-based personality. I just don't have patience like Dawn does to say, hey, here is a way to think about it, and here's a possibility and whatnot. I'm like, listen, you dumbass, here's the answer. Just come to it, because
like that patience. It's like I'm impatient too.
Yeah.
And so it's like I'm like a let's cut to the chase. But the brilliance, I think, in a lot of what Mr. Keenan does is it's just he like just steps back and and it's just having that. You know, it's that confidence though too, and that's, you know, all part of. If there's one thing that KTI has given me, is confidence, and so just being able to, and that's just when you do all the work that you should do, you can have a better understanding of what's going to come out. I think at trial there's that fear in the unknown, but I'm thinking of a couple of things that students will get in this course that. There are such, you know, some of the courses, or excuse me, some of the cases that Dawn has had are highlighted in the Damages course. And the injuries and the suffering and the loss are just, you know, palpable, right? But he had chosen to present those damages in such a way that, you know, pardon my French, most lawyers were just completely screwed up, right? Because it's so obvious, but the things and the ways and the tools that he chose to show the damage are like, holy shit. Because I would have been the bull in the china shop. And, you know, whether it's showing the horrible photos or whatever the case may be, he does this one thing and that's it. And you don't need to say it. It's like the drop the mic. That's what it is. It's really, how do you whittle down what you have and understand the one or two important pieces of evidence or testimony, whatever the case may be, that are just enough said. That's it. So gaining that confidence in that regard, I absolutely believe that the Damages course will help with that if that's something that you struggle with.
Absolutely. And then with all of this, everybody, just remember to keep trying to try cases as much as you can. You know, I mean, I know a lot of what Edge gives us is the power to resolve cases and really kind of bring the defense to their knees early on, or should say after all of the work, but then before trial. But and I mean, I remind myself of this constantly because we don't get into the courtroom enough over here, especially, in the past couple of years with continuances and stuff, of course, but going in there and getting it done, trying this stuff out, using it, putting it into practice, seeing how it works, and then going back to the drawing table and doing it again and getting better at it. Because you can hear it, talk about it, go to all the colleges in the world, but if you're not putting it into practice and seeing how it works and then how you want to tweak it and then how you want to fix it and how you want to go to another course to remind yourself,
100%.
it's just, you got to be putting it into practice and doing it.
Can I just give a little plug for a course that I haven't taken yet? I'm going to take the cross exam course in the end of May.
Mm-hmm.
And to your point, in trial, when I was doing a cross exam, I had a particular moment, and I was telling, who was I telling this to? One of the other instructors. I was like, my weakest link at trial, I feel like, is cross exam. And I went into the trial with that fear, and I definitely got caught up in it. And I thought, God damn it, I don't want this to ever happen again. And so so you're spot on it. And it's the only way that you can truly know that is if you're trying cases. So, and that's where the experimentation comes through. And that's also where you can, make your mistakes and which courses you need to take.
Yes. Yeah. Or like maybe you thought you understood a concept and you put it into practice and it didn't quite come out right. And and focus groups are really good for that, right? Because you want to practice them, but you got to get out into the limelight and do it and really
100%
fall on your face and
just ask me if you're feeling bad after falling on your face. I've done it so many times that I will make you feel better. So
yes, everybody falls on their face, and we're just climbing back up from having fallen on our faces. So
gluttons for punishment. Yep.
Yeah, but it's good for you. It's character building.
That's right. That's what my mom always told me.
Oh, really?
Linda says it builds character, and I was like, hang up on her. I've enough.
I know.
Linda.
Well, I don't want character.
That's right.
Well, thank you, Kari. And thank you so much to everybody who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you like today's episode, please click that thumbs up button to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we're going to continue our KTI faculty speaker series with Toby Cole, who is going to speak to us about the openings college, the undergraduate openings college. And I want to be specific about that because we'll probably do a graduate series later this year, but this is going to be the undergraduate one. Toby practices personal injury law at the Cole Law Firm in Houston. And he taught me my very first Edge college ever, which was opening statement. I look forward to learning how things have changed and what's new in this college course from Toby next week, along with all of you. So have a wonderful weekend, and I'll see you next time.